The next important concept in Unit 4 is diplomatic agents. So, what do you mean by diplomatic agents? The persons who reside in foreign countries as representatives of the state sent them. So, these diplomatic agents they reside in foreign countries but they represent their home state. They are sent by their home state. Immunities and privileges to diplomatic agents. So, what are the immunities and privileges or rights provided to diplomatic agents? The first is inviolability of persons of envoys. So, Article 29 of the Vienna Convention on Diplomatic Relations 1961 says that the diplomats cannot be arrested or detained and they have to be treated with respect and protection to their person, freedom, and dignity. So, this is called inviolability. That they cannot be arrested and their respect they have to be given respect. The next is immunity from criminal jurisdiction of courts. So, they are immune to any criminal jurisdiction of courts except in criminal conspiracy. If the diplomatic agent is involved in a criminal conspiracy, then he does not have any immunity. The next is immunity from civil jurisdiction. So, even in civil jurisdictions, civil courts, diplomats have immunities. They need not go there. The court cannot try them in foreign countries. Exceptions. If he is involved in private immovable property, then he can be prosecuted. He can be tried in civil courts. If he is involved in succession, heir, he is an heir and property has been transferred to him, then the civil court can try him. And any commercial activity not for state. If he does any commercial activity which is not for the state, then he can be tried in foreign civil courts. Other than this, he cannot be tried in civil courts of foreign courts. The next is immunity regarding residence. He can own any residence he wants in the foreign country. The next is immunity from being presented as a witness. So the court cannot call a diplomat for witness to be a witness. The court cannot force him. The next is immunity from taxes, dues, etc. He need not pay any taxes. The next is immunity from police rules. So police rules of foreign countries do not apply to diplomatic agents. The next is right to worship. The diplomat can worship any religion he follow any religion he wants. The next is right to exercise control and jurisdiction over their officers and families. After that, right to travel freely in the territory of a receiving state. So he can travel freely within the foreign state. The next is freedom of communication for official purpose. He can communicate his home state whenever he wants. He has that freedom. Immunity from inspection of a personal baggage. In airports, his personal baggage should not be inspected. Immunity from social security provisions. So these are his rights, immunities, and privileges. The next are duties of a diplomatic agent. He should respect laws and regulations of receiving state. The state where he is residing in the foreign state, he should respect their laws and regulations. Not to interfere in internal affairs of the state. He should not try to interfere in the internal matters of the state. Official business conducted through Ministry of Foreign Affairs of receiving state. So any official business he is doing, he should only do it through the Ministry of Foreign Affairs of receiving state. Premises should be used matter incompatible with the mission. So premises should be used only with the for the mission. You should not use that premises, his home, for any matter which is incompatible with his mission for which he is sent there. Not practice profit, personal or commercial activity. So he should not practice, he should not set up any commercial activity, any business for his personal profit. The case is United States diplomat and consular staff in Tehran. In this case, it was held that if a person is wanted, he is criminal, and he has no immunity, then the diplomat should hand over that person to them. The next concept is consuls. So, who are consuls? Consuls are representatives of state, but they are not diplomatic agents. They are also representative, but they are not diplomatic agents. So, object, why consuls are sent to different states? They are sent to different states to control commercial and trade business of the state. They only look after the commercial and trade business of a state. Functions of a consul: to protect commercial interest of a state. He should look after the commercial interest of the state, any business and trade and everything. Then he should supervise shipping, the flow of goods or the transport of goods from one state to another state. He should look after it. Then getting passport to citizens. The citizens who are residing in the foreign states, he should help them in getting passports. Other functions for citizens like registration of marriage, births, etc. in the foreign country. These are his functions. The next important concept is treaties. So, what is a treaty? Professor Schwarzenberger defined treaties as it is an agreement between subjects of international law, creating a binding obligation in international law. So, it's basically nothing but an agreement between the subjects of international law. It can be between states, it can be between individuals, it can be between international organizations. So, it is an agreement between subjects of international law. But after that agreement is done, it creates a binding obligation. It will be binding on the parties in international law. Formation of treaties. How treaties are formed? The first step in formation of treaties is accrediting of persons on behalf of contracting parties. So a representative is selected first by the state to represent them for the treaty. The next is negotiation and adoption. These representatives they go into negotiation, and after the negotiation is successful they adopt it. The next step is signatures. After adopting the treaty, they will sign the treaty that they have accepted it. And the next step is, and the most important step is ratification. Even though the representative have signed, there should be a ratification from the state heads of their respective state. The government or the state officials or the state heads should ratify it, should confirm that they have accepted the treaties in the next step. The next step is accession or adhesion. So the states who have not accepted the treaty, there is a provision is made in the treaty that those states may later on accept the treaty. This is accession or adhesion. The next is entry into force. When this treaty will come into force is decided. And the next is registration and publication. The registration of treaties are done and its publication is done. And the next is application and enforcement. It is applied and enforced. The next step. The next important concept in treaties is reservation in treaties. So, what is the meaning of reservation in treaties? After treaty is made, states claim to modify or exclude certain provisions of treaty. So, the treaty is done and everything is done. Thus, they have signed, they have ratified. But after that, the state goes on and claims that it will modify certain provisions of the treaties or it will exclude certain provisions of the treaties and imply it. So, Article 2, Clause 1 of Vienna Convention on Law of Treaties 1969, this is about reservation, it is mentioned. So, Article 19 of this 1969 Vienna Convention says that state may formulate a reservation. So, state is allowed to do reservations like this unless prohibited by treaty. If the treaty prohibits that a reservation cannot be done, then the state cannot do reservations. The treaty only allows a specified reservation. If it is specified in the treaty that they have to do only that they can only do specific reservations, only on this part they can do reservations, then the states are allowed to do reservations only on those parts of the treaty. Article 20 says about acceptance and objections to reservations. So if a treaty provides acceptance not necessary, so if a treaty in rules of treaty it is mentioned that states can do reservation, then the acceptance of state is not necessary. Consent of all parties is essential. If the treaty specifically mentions that for reservation consent of all parties is essential, then the state who is reserving the treaty should take consent of all the parties. If to international organization, their acceptance. If the treaty is involved, if in the treaty international organization is involved, then if the state is doing reservations, then it should compulsorily take acceptance of international organization. The next is accepting validates reservation. Say if a state reserves the treaty and the other state accepts it, then it will validate the reservation. If one state objects, it does not affect treaty and reservation. So if only one state to the party objects, then it will not affect the treaty or the reservation of the other state. If one state accepts a reservation is valid, among all the parties, if only one state accepts the reservation of the other state, then the reservation will be held as valid. Article 21 Effect of reservation. So, what are the effects of reservation? It modifies treaty to extent of reservation. So, if the states accept the reservation, then the treaty will be modified to the extent of reservation. So,